Every person who signs up with Printify has aspirations of freedom, career, time, or financial, maybe even all three. But all of your hard work could come to a crashing halt if you don't know about IP or intellectual property infringement and its potential consequences. So let's have a conversation about the big no-nos of creating and selling products and the red flags to be aware of so you can begin or continue creating, selling, and making profits. You know that feeling when you're finally made your first organic sale or one of your products is well on its way to becoming a bestseller? It's pretty nice. But when sellers do this by illegally cutting corners, whether they're aware of it or not, it can cause damage to both your brand's reputation and business permanently. But there are ways to educate yourself, learn from your mistakes, and move forward. I'm here with Titus, who's an IP enthusiast here at Printify, to discuss some of the common questions and misconceptions when it comes to IP infringement. A quick disclaimer, this is not professional advice. This video is for informational purposes only and does not constitute professional advice. The content is based on our general understanding as of the date of recording. Viewers are encouraged to seek advice from qualified professionals for specific situations. Actions taken based on this information are at your own risk, and Printify is not liable for any losses or damages. All right, hey Titus.
Hey.
Let's get started with the basics here. What constitutes IP infringement?
It's pretty straightforward. An IP infringement is whenever somebody uses an intellectual property asset in their design without respective authorizations. For example, if you want to use Printify logo in your t-shirt, that would constitute an IP infringement. And in that case, Printify would block this product.
Could you explain further why Printify might block certain products and what are some of the criteria that are used for this decision?
Yeah, so as a platform, we are obliged to react sometimes for IP infringement. We are obliged to react to legal notices from third-party intellectual property rights holders. And on top of that, we have some systems in place to ensure that we are ensuring intellectual property compliance on our platform. And in such case, if we flag something, we would block the product. Usually this would be in case of, a person using a logo of a third party, let's say again, Printify logo. In such situations, we would block the product based on our internal systems and processes we have in place.
How can a seller then identify if a product has been blocked?
We have two ways of notifying them. One way is sending an email, which indicates that the product has been blocked, provides more insight on what they can do. And the other way is you can go into your Printify account. Under My Products, you can filter out IP infringing products, so to say, status for the respective products.
Can you tell us a little bit why Printify doesn't disclose specific reasons for blocking a product? And without this specific information, how can sellers fix an issue that they might be unaware of?
So that's basically because our emails are automated, and we want to ensure that we can cover with the email as much or as broad the audience as possible. And on top of that, merchants are responsible for ensuring that their products are not IP infringing themselves. However, if they reach out to us and ask for some clarifications or something like that, we can provide a short indication on, hey, we know our system flagged this potential logo or something like that in your design as potentially infringing, or a third party reached out saying that your products are infringing, and because of that we had to react.
So when in doubt, kind of best to go to a legal advisor and maybe find out what could have been the issue.
Definitely, precisely. Best go to your legal advisor before you create the products, or when you create and before you start selling them. But it's also good to reach out whenever there's a potential infringement.
Okay, let's switch gears here just a little bit to the kind of design and listing aspect now. When selling products, what aspects of the actual product or listing are susceptible to IP infringement?
Everything. It goes from product description to product design and everything in between. Product title, product tags, whatever comes into your mind in respect to the product itself, it's protected under intellectual property rights. You should not ever use, specific phrases or keywords in your product title or description.
And can this include like mock-up photos as well?
Oh yeah, definitely. So one of the reasons why we should not use any, potentially infringing keywords or phrases is because consumers might confuse the product as being endorsed by the respective brand owner. Let's return back to the Printify logo. If you want to use Printify logo, you need to get the respective authorizations. And if you want to indicate to your consumers or your end consumers that you are selling Printify merchandise, you will probably indicate, hey, this is a Printify t-shirt. And in such case, because of the title itself, the product might be blocked because it can indicate that there's, some affiliation between Printify and you, while there is none.
Without having the proper permission. Yeah.
Precisely.
Okay. What about guidelines when it comes to using people's names or likenesses and images of public figures, celebrities, actors, or even politicians?
Well, this is a complex question, but to put it shortly, any person has right to privacy. So if you're using a product design which includes a politician, which is usually considered a public person, even in such situations, I would say you should reach out to your legal advisor to make sure that you're not, overreaching the boundaries of right to privacy. And whenever using photos or names of persons, this is definitely something you should be very careful of, not to overreach the boundaries of right to privacy.
So when in doubt, probably best to just not do it,
Always,
right?
yeah. And reach out to your legal counsel, right?
Right. Okay, let's talk a bit now about the actual design creation process. How might handmade or original designs inadvertently infringe on intellectual property?
So even without you wanting to infringe on intellectual property, in such situations as you described, there can be an intellectual property infringement. That's because, all of us are influenced by whatever is around us. We are influenced by the advertisements, by movies, by anything, by books and everything else. And because of that, in case of, even your own designs which you have created on your own, they might include some, aspects in the design which might be intellectual property infringing. Again, let's use the Printify logo example. You might want to use the snap. However, it might be flagged as potentially IP infringing because of the similarity to an existing logo.
What about when using elements from a paid design platform like Adobe Express, Kindle, Canva, all those different softwares or subscriptions? What is and isn't allowed?
So all of these systems and softwares have their own terms of service. And these are the best source for understanding what is or what isn't allowed. So I would suggest definitely, going thoroughly through the terms of service. And usually such terms of service would indicate, whether a design or whatever you create there or purchase from there, whether it's permissible to use for non-commercial use or also for commercial use. And at the end of the day, you will be responsible for making sure that the design is not infringing on intellectual property. So you need to make sure that you read the terms of service as well.
And not just for your design platforms, but even for Printify, you can read our terms of service. We'll link the description down below, but we kind of talk about some of these things as well.
Precisely,
there.
yeah.
Are designs obtained from platforms that are offering free resources subject to similar restrictions?
Definitely. I would say they are even more, restrictive, because usually when there's something for free, it's usually, you can use it only for, non-commercial use. As anybody using Printify, or most at least most people using Printify, they are doing it to make money. For commercial use. So in case of using free services, be sure to check, whether you can use it for commercial use.
Okay, let's talk about now, instead of someone making their designs, maybe they're hiring someone, a graphic designer, or an artist grants permission to sell a design. How can the resulting items still infringe on copyright?
That's where, pretty similar whenever you create something, right? The designer is also influenced by whatever is around us. And because of this, they might create a design which might inadvertently or not intentionally infringe on intellectual property. So, be sure to check what you can on the created design, as at the end of the day, you will be responsible.
Right. What about public domain and Creative Commons licenses? How do those differ, and can designs under these licenses be used in our online shops?
This is a bit similar to what we discussed previously on rights to privacy, right? It's a bit more complex topic, but to put it shortly, public domain images on public domain, you can definitely use them because those are usually historic images from a long time ago, and they do not enjoy the intellectual property right protection. However, Creative Commons licenses are whenever you are using somebody's designs or work when they have allowed it, and in such situations there are specific restrictions you need to follow to ensure that you can legally, so to say, use it. In both situations, definitely you should reach out to your legal counsel to make sure that this is, the proper way on how to use it. For example, a great example right now is Steamboat Willie from Disney, first version of Mickey Mouse. Steamboat Willie is currently in public domain, right? But at the same time, there's Mickey Mouse, which is still under intellectual property, so to say, protection. As Mickey Mouse has had several iterations, each iteration has its own, so to say, term when it will become in public domain. So when in doubt, definitely reach out to your legal counsel. I can't express it enough.
Yes. Okay. So we have some relatively new technology now with AI. What are the current legal statuses and considerations for AI-generated images and using those in your designs and products?
So generally, you can definitely use it. The thing here is that AI is developing on daily basis. So also the practice or how IP law applies to AI, it also develops on daily basis. Generally, at the time of this recording, right, AI-generated images are not protected by copyright, for example, in majority of places. However, there are some places where they enjoy copyright protection. So I would say you can use the AI tool for generating images, but be sure that there are no intellectual property violations in the design or the image. At Printify, we have seen several images actually which have been generated by AI, which includes third-party intellectual property rights, and in such case we block the product and notify the merchant.
So can we use that Mickey Mouse as an example again? If you tell AI generate something that looks like Mickey Mouse, that would be clear infringement, right?
That would be, definitely.
Yeah.
Because at the end of the day, we want to make sure that the designs are not confusing consumers. And that's more or less the threshold we are looking at. And if an AI generates a Mickey Mouse lookalike, then we'll probably be forced to react and block the product.
Right. Okay. Are there any tools then available to identify trademarks, copyrights, and potential IP infringement in designs?
There are. The most simple tool is your own browser, right? You can go into several public registry databases and then search for your respective trademark name or potentially copyright. In addition to that, of course, there are some softwares. But again, remember, if you are using a software, you will be ultimately responsible for making sure that the design is not infringing on intellectual property.
Right, and I think in the U.S., the USPTO, or the United States official trademark office, they have a search database. You can look for some of these things. But other countries, like you mentioned, they might have a public registry where you can kind of check if something's being used or has already been trademarked.
Precisely, yeah. And in the US, you can also register copyright. So you can also search for copyright, so to say, registered copyright.
So if a design element then does not appear to be trademarked or copyrighted, can sellers use it?
Oh, definitely. I mean, if you are confident enough that the design is not infringing on intellectual property rights, you definitely should use it, especially if you want to make money, right?
Exactly. And then if someone just decides to disregard copyright laws, what are the consequences for these sellers?
Oof, I mean, the scope of the consequences are pretty broad, right? It can be from a monetary fine, the amount also varies on different kinds of situations, and it can even go up to criminal charges.
So flipping the coin then, how can sellers who have created, or how can sellers, if they want to use somebody else's design, how can they apply for or obtain a commercial license or get permission to use these names or images for their merch?
So in that situation, you definitely need to reach out to the said person or brand owner or IP holder. It might be, the person itself, or it might be an agent or something like that. And then just start negotiating a potential agreement on how you can use their respective intellectual property. It can be a licensing agreement. It can be any other sort of agreement which prescribes and details how you can use the respective intellectual property rights.
Okay, now flipping the coin a little bit, if you are the one who has created a unique original design, in case of design theft here, what steps should a seller start with? Or under what circumstances might a merchant consider legal action or even just consulting with an IP attorney?
So, generally speaking, consulting with an IP attorney would be beneficial in any situation, as I have mentioned several times today. But if you notice that somebody is using your designs, first of all, you definitely need to reach out to the person who's potentially infringing on your design or your intellectual property. On top of that, if you believe that they are using Printify, you can reach out to Printify, and we will check whether the person is actually using our platform, and if they are, then we would react and make sure that the respective products are blocked, and potentially even suspend the respective merchant.
Well, fantastic. Thank you, Titus, for joining us today in this conversation. Now, we know we just threw a ton of information at you, and you might feel a bit overwhelmed, but it's okay to not know everything right away. The main goal is to familiarize yourself with the basics and everything that comes along with creating and selling your own products. Now, researching is just the beginning here, and you can rewatch this video as many times as you need to keep yourself educated. And make sure to like and subscribe if you want more educational content just like this. And if you're curious about those Creative Commons that we mentioned, go ahead and check out this video.